The contract of agency is an in tutu personae relationship. It is built entirely on the specific personal characteristics of the parties involved, relying upon mutual consent and strict fiduciary confidence. When that confidence shatters, the representative relationship simply cannot survive. Because this trust is personal, any event that destroys a party's legal capacity, physical existence, or solvency severs the relationship by operation of law. This forensic audit of Civil Code Articles 1919 through 1932 tracks how these mandates end and identifies the specific residual liabilities that remain once the authority is gone. Distinguishing between an extinguished agency and one that legally survives is the primary factor in determining who absorbs financial liability when a terminated agent continues to transact with third parties. Article 1919 establishes the baseline for the doctrine of fiduciary termination. The loss of physical presence, capacity, or solvency terminates the mandate. We categorize the 6 statutory modes of extinguishment using the acronym EDWARD: expiration, death or disability, withdrawal, accomplishment, revocation, and dissolution. A common point of confusion is insolvency. Even if an agent remains mentally competent, financial ruin destroys the required fiduciary reliability. There is a narrow jurisprudential exception to this rule. The specific power to foreclose a mortgage survives the death of the mortgagor. Under Article 1920, the principal may revoke the agency at will. Because the relationship exists for the principal's benefit, they can end it at any time, regardless of prior irrevocable clauses. There is a distinction between the power to revoke and the legal right to do so. A principal who revokes in bad faith to evade obligations, such as avoiding a broker's commission, is liable for damages. Upon revocation, the principal may compel the agent to return the document evidencing the agency, such as a special power of attorney, to prevent the agent from misrepresenting their authority to others. While final control over the relationship lies with the principal, using that power to abandon contractual duties triggers a financial penalty. Article 1921 addresses protections for third parties when the agency was created specifically to contract with certain individuals. In these cases, the principal must provide actual, personal notice directly to those specified persons. If they fail to do so, any contract the third person enters into with the agent remains fully binding on the principal. Article 1922 provides a different rule for agents with general powers who deal with the public at large. For general powers, personal notice is not required. Publication in a newspaper of general circulation serves as constructive notice, which prevents any third party from later claiming they acted in good faith. The burden of notification scales with the scope of authority. Specific targets require direct communication, while the general public is notified through constructive publication. Extinguishment can also be implied through conduct. Under Article 1923, appointing a new agent for the exact same transaction revokes the previous agency. This implied revocation only becomes effective against the former agent on the day they receive notice of the new appointment. Under Article 1924, a principal directly managing the business revokes the agency. Article 1925 states if multiple principals appoint one agent, any single principal can sever the agency. Lastly, Article 1926 allows partial revocation. A special power carves out specific authority from a general power. The law prioritizes operational facts over written titles. If the principal's actions are incompatible with the agent's authority, the conduct effectively terminates the mandate. Article 1927 provides the strict exception to revocability, an agency coupled with an interest. When the agency is the method for fulfilling a pre-existing obligation or a bilateral contract, it is no longer a simple fiduciary service. It becomes a vested property right. Here, the principal loses the power to revoke. The authority must remain in place to protect the material interest the agent holds in the subject matter. The mere presence of the word irrevocable in a contract does not make it so. The protection of Article 1927 only applies if the agent holds a factual, material interest in the business being transacted. When an agent acts to secure their own financial right, rather than just serving the principal's will, the law prevents the principal from terminating the authority. Agents also have the power to leave the relationship. Article 1928 allows an agent to withdraw at any time, a right protected by the constitutional rule against involuntary servitude. A valid withdrawal requires due notice to the principal. If the agent quits without just cause and the principal suffers damage, the agent must pay indemnity. The agent is excused from paying these damages only if continuing the agency would cause them grave detriment, such as a severe health crisis. Article 1929 imposes a temporary holdover duty. After a valid withdrawal, the agent must continue acting until the principal has a reasonable opportunity to find a replacement. This is the WCR mandate. Withdrawal requires continuation until reasonable opportunity. Agents who abruptly abandon assets and allow them to perish remain liable for the resulting damage. While the right to quit is absolute, the law requires a transition period to prevent a vacuum of responsibility that would prejudice the principal. While death usually ends the mandate, Article 1930 ensures that an agency coupled with an interest remains in full effect even after the principal dies. Article 1931 provides equitable protection for acts performed after the principal's death, but before the death is known. This rule requires dual innocence. A contract made after the principal's death is only valid if both the agent and the third party were completely unaware of the death. Philippines must be unaware for the protection to apply. If the agent is the one who dies, Article 1932 shifts a temporary duty to their heirs. These heirs do not inherit the authority to act as the agent. Their duty is limited to notifying the principal of the death and adopting immediate measures to preserve the principal's interest. Death terminates the legal personality of the parties, but the law requires surviving players to manage the transition according to these statutory rules. The extinguishment of agency is a balancing act between respecting the consensual nature of the contract and protecting third parties who rely on apparent authority. The Civil Code honors the personal nature of the mandate by allowing unilateral severance, death, and insolvency to terminate the contract by operation of law. This termination is checked by statutory protections, notice requirements, holdover duties, and the irrevocability of vested interests. Understanding how these specific statutory triggers terminate, sustain, or mutate the relationship is essential for navigating the liability traps common in agency problems.